Hey there, John Michaelides, Real Property Management of Sarasota and Manatee. I trust that all is well with you and yours. I recently had a question from a rental owner. They asked me, what entity should I set up to hold title to my rental house in Northport, Florida? It doesn't matter where it was, right? What entity should I set up? So first of all, what is an entity, okay? An entity is something, a legal construct, if you will, a corporation, an S corporation, a trust, a limited liability company, otherwise known as an LLC. It's some kind of legal construct that's set up by an attorney, paperwork essentially, that's filed, and now that paperwork becomes recognized under the law. So, in other words, if I set up ABC Holdings to take title to a house that I own in Sarasota that I use as a rental, as long as it's set up properly, all the rules are followed, and title is placed into the name of ABC Holdings as opposed to myself, John Michaelides, then John Michaelides does not own that property. I own the entity, but I don't own the property. The entity owns the property. I own the entity. So whatever's in the entity, I own indirectly through the entity. Why the hullabaloo? Why go through this? Primarily, now there's several reasons. Tax planning purposes, succession planning, what happens after I pass away to the property, that's succession planning, and also liability shielding. There's different entities and there's pros and cons to the different entities, so we're not going to get into which one is right for you. You have to talk to your attorney about your particular situation, but we're talking about liability shielding, right? So somebody moves into the house and it's held by John Michaelides. Roof caves in, person's injured, there's a judgment, they sue. There's a judgment against who? John Michaelides. John Michaelides owned the house. Not only can they go after the value of the house, equity in that property, but since the judgment wasn't against the property, the judgment was against me personally, that means I am liable for what happened. So if there was a $100,000 judgment and there's only $50,000 equity, guess what? They can come after my personal residence, a boat, a car, a motorcycle, my watch. They can come after me personally for that judgment until it's paid off. Now, let's say we set up ABC Holdings. It was set up properly. All the rules were followed. Title to that property was placed in the name of ABC Holdings, not myself. Roof caves in, person is injured, $100,000 judgment, $50,000 equity. The judgment is against ABC Holdings, not John Michaelides. ABC Holdings only has $50,000 in equity. There are no other assets in ABC Holdings. That $50,000 goes to that tenant who won the judgment, but guess what? It stops there. They can't come after my assets because the judgment wasn't against me. It was after ABC Holdings. So do you see why I recommend that you never, ever, 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 did I say ever enough? Ever hold your rental real estate in your name personally. Now, there may be some wild and crazy reason why you should that I can't fathom. That's why you've got to speak to your attorney who knows your situation, but at least have that conversation, okay? So, speak to your attorney, various types of entities that you may want to form based on your situation, but you should probably seriously consider entity structuring. And guess what? If you already own rental real estate in your name, no big deal. You can still form an entity and have the title to that property transferred out of your name and into the name of that entity. Okay, John Michaelides, Real Property Management, Sarasota, Manatee, beautiful Gulf Coast of Florida. Should you have any issues or questions regarding leasing and management of residential properties, that means single-family homes, condo units, small multifamily units, duplexes, triplexes, 10 units, etc., contact Real Property Management of Sarasota and Manatee, 941-225-8183. Good day and God bless you. Bye-bye.